Oh, and Stephen has joined us. Hi, Stephen.
Good noon.
All right. Okay, and there's Satpal. Hi, Satpal.
Hi.
Nice to see you. Okay. Well, I was just saying to the group when Jill reminded me that we need to start recording that we have a fairly open agenda today. When we ended our last meeting, which I think was a month ago, we all agreed that we would give some thought to how we would like to see the pretrial services unit utilized during this time when jail releases have been, when there have been more jail releases than we were dealing with before COVID. And knowing that we're in a kind of temporary situation where the jail is overcrowded and the people in the jail are for the most part, very appropriately jailed, I think. Would you, Judge Freeman, would you say that that's an accurate description of the status quo?
Yeah, I would. It's certainly a different jail population than we had about 3 years ago.
And so I think that the focus of pretrial services should change as a result, because there's less of a need for monitoring to make sure that people make their court dates. We've got a lot fewer court dates for people to make pre-trial because the court rules have changed. So people don't have to appear in person nearly as often as they used to. But we also have a needier population, if that's a accurate way to put it, and I think it is. And so the focus of pretrial services can change, and in many ways that makes its focus more compatible with some of the other court-related services like those that the LEAD program offers. Have I described the status quo accurately in your views, Alan Epps and Adam Fryer?
Yes and no. I would say, yeah, the population has changed a bit, and there is a need for us to kind of keep up with the times, so to speak. But I also think just at its basic level, we could be utilized more. I've been doing some kind of seminars and Zoom classes, and the consensus, I guess, is that less is more, especially pre-trial. You know, too much monitoring or too many check-ins and things of that nature, and too many restrictions will actually give people less success pre-trial. So I would like to see just more numbers being referred. For instance, if there was a policy or something put in place that would have the weekend PC people, the people that post low bail or no bail, if they're automatically referred to like medium pretrial services, where I follow up with them on, let's say, Monday or Tuesday or whenever I'm back in the office doing PSAs. I think that would be beneficial, especially to those people that were, deemed to have a low bail or no bail situation. So I think there's already room for growth just with our current setup, but I don't disagree with you saying that it'd be nice to expand or do something else also.
Okay, thank you, Alan. And yeah, that's an example of ways in which we can kind of fine tune pretrial services. Dave Freeman, yeah, I see you there. What do you think about that potential for an automatic referral to pretrial services for the weekend PC people?
Yeah, I definitely think that's a possibility. I was just going to chime in. Those of us that met with Thurston County, that is essentially their policy. Virtually everyone facing a felony was placed on some level of pretrial supervision. So I don't know if that's something we want to explore more, but that was a suggestion coming out of Thurston County.
Yeah.
And if I could interject again really fast, piggybacking on what Judge Freeman was saying, I agree completely. I think at some level, these individuals should be being referred to pretrial. Now, I have spoke with Dave in the past, Dave Reynolds, and our current system already yields itself to having automatic text reminders put in place. And Dave, if you could confirm, I think that's what you said.
That's correct. Regardless of if they're on pretrial or not, everybody with a pending court hearing gets text messages.
Which has been
So,
very,
yeah.
I understand. Well,
Yeah,
remember.
and even the people I've contacted who are placed on pretrial, I mentioned, hey, would court reminders, something as simple as court reminders work? And they're like, oh yeah, I'm already getting those, or I just started getting those, and they absolutely love that feature. And that's one thing that pretrial does, along with the volunteer referrals and the weekly or the monthly check-ins and things of that nature, just to keep people on track. But having, well, let me back up a little bit. I think right now, the way our current matrix is set up, we're having a lot of people score high. And I don't know if the time Judge Freeman and Stephen have worked with Thurston County or spoke with Thurston, I don't think the majority of people should be falling on the high level, the intensive management. It should be more, monthly check-ins or once every 3-week check-ins, not intensive management. So I do believe, after I've kind of thought about that, I do believe that we need to kind of either adjust the matrix or refer people more at the medium level.
Alan, let me just ask you, and you may not know, because I'm definitely asking you something that's better sent to Andrew Peterson, but do you have a sense of why people are scoring high? Is there a certain category in prior crimes that is raising those scores, or can you generalize about that?
I can generalize, yeah, especially now since I've been doing all the PSAs for the last 3 months. I think they really get bumped up when it's how many warrants they've had in the past 2 years. There's one question that says, do they have 1 warrant in the past 2 years, 2 or more warrants in the past 2 years? And that typically jumps them up. If they're low, that brings them to high, or medium instantly. If they're medium, that brings them to high. So the FTA is weighted pretty heavily. And then prior violent crimes, those 2 questions are weighted pretty heavily. The pending charges or the prior misdemeanors or prior felony questions, those don't seem to be weighted as high.
Interesting.
Because, well, and also expanding on that, the PSA, it's kind of funny because if somebody comes in, let's say with a charge, and I have to answer the question, yes, pending charge, it doesn't ask me how many. So there could be an individual coming in with 1 pending charge from 2 years ago, or there could be a person coming in with 5 pending active felonies within the last year, and the PSA doesn't care. The PSA, it's exactly the same score.
And yet the PSA gives them 1 point for each warrant they've had in the last 2 years.
Correct. Yeah, the warrants are weighted pretty heavily.
Well, on the other hand, that's a relevant category. Dave, Graham, do you have anything to add from your observations?
Well, I mean, it's tough to say we need to change the matrix. We're just seeing more serious crimes. I mean, we talked about that pretty much every meeting, that people we're seeing at the jail are being held at the jail because they have pretty serious issues. Most of the ones who would be the low, even medium supervision are getting PR to the jail, book and release. I mean, like today, Friday, we did the arraignments. We probably had 7 or 8 folks who, normally would have been booked and held on to first appearance, but they were PR'd because of overcrowding, to show up to a Friday arraignment. Very few of them showed, but that's another issue. But I mean, even look at the calendar today. I mean, we've got a, pretty serious assault 1. We have a sex offense. We have the only really property crime we have is an embezzler who's probably going to get out anyway. He probably doesn't have any history, but most of the folks we're seeing at 3 have pretty serious histories. So I know Alan's seen it. I don't even know if adjusting the matrix is really going to help us. It's just the type of crimes we're seeing.
Yeah, and you might be right with that, Dave. It may not help to adjust the matrix because a lot of the people who are landing in high, they're usually in the bottom right corner, which I wouldn't remove from high in the bottom right corner of that matrix. I think that's appropriate. So you're probably spot on there.
Which one thing I think as we're talking about risk levels and monitoring levels, I know one of the things that we liked as a work group about the PSA is it can separate and distinguish among different kinds of risks. And I think that's part of what this discussion is pointing at. Like, are we as concerned about a risk of failing to appear in court, or are we more concerned about a risk of towards future violent crime? And I think as we're looking at the potential for the pretrial services unit, I don't have any disagreement with anything that's been said, and I support the caution to try not to over monitor people or create risks of procedural violations that aren't really meaningful from a community safety standpoint. But I'm also wondering if this is an opportunity to take a little bit closer look at some of the high safety risk or high risk of future violent crime folks and see if there's more that could be done to support monitoring of those people. I know bail gets set in many of those cases, but I also know that many of those folks post bail and then they're out. So if we have this resource of the pretrial services unit, you know, are there situations where someone's substance use concerns overlap with risk of violence in the community or safety risks for specific people? And in those cases, would it be a helpful thing for our community if the pretrial services unit had the capacity to monitor for substances or work with the court on court conditions around substance use, just as one specific thing that I know is available in monitoring in district court, but has not been an option yet with the pretrial services unit.
I don't really have a direct comment to that, but I believe that should be explored.
Judge Garrett, you're on mute.
Judge Garrett, you're on mute.
Too bad. I said the most insightful things. And yeah. Okay. A couple things. Are you hearing me twice? Is there an echo? I'm only connected on one device.
I am.
Okay.
Dave Reynolds, could you mute your computer a second?
Can we mute the conference?
Yeah, thank you. Oh, it looks like they just muted it, so we should be good.
Oh, okay. Sounds good. Well, actually, what I was saying was telling Alan Epps that his comments were being distorted, but I think it was probably by the same distortion agent. So let's just hope for the best and go ahead. Andrew Peterson, I'm going to put you on the spot. And if you can't, if this isn't something we can know in a quick way, that's fine. But what I'm wondering is there a way in the statistical analysis that you're doing to get a better sense of where those high scores are coming from? How like, in other words, what proportion of the high scores are coming from situations where we've got a high level of prior felonies and or a high level of community safety concerns versus a high level of concerns about failure to appear? Is it possible to break that down with the numbers that you've got at this point?
Sure, forgive me, I think my internet's a little unstable at the moment, but that should be knowable. I mean, because Alan does a good job of entering case numbers along with his data of the PSA. We should be able to match it to AOC records and then figure out kind of, do a retrospective on what created those scores, what's driving those scores, whether it's, like you said, criminal history or warrants or whatnot. I think the only factor that is difficult for us to measure with some certainty is the PSA asks about, do they have a prior incarceration of I think it's 14 or more days? And that one, because those are in jail records or DOC records, not always accessible to us. So I think that's the only factor. And I don't think that's heavily weighted either, but that's the only factor that may be hidden from us somewhat.
Okay. So can you report back to us at the next meeting with your findings in that regard, as opposed to those two causes or those two potential causes of the high scores?
Sure. My only question then is, you mentioned this maybe a more recent phenomenon is, I think the analysis I did before this was going back to, what was it, September 2019 through the beginning of this year. Should that be broken out somehow, or is there emphasis on more recent numbers? Is there a preference there?
Well, I would prioritize the more recent numbers most highly. As always, it's always nice to have numbers that go back to pre-COVID levels, because that's the closest we get to the normal state that we were back in the good old days and we didn't know it at the time. So it's always good to go back, but it's really the more current numbers that I think are going to drive the discussion of how we adjust to this. So I guess it's dependent on your energy level, Andrew.
Okay, well, I'll see what's possible, and then maybe kind of emphasize the last 6 months or something like that.
Okay, that sounds good. Adam Fryer, do you have anything to add to this discussion from the lead perspective?
Not at the moment. No, just taking it all in.
Okay, well, feel free to jump in if you have some insights. And
Dave Reynolds and Stephen Gockley have their hands raised.
oh, I'm sorry, I'm not very good at noticing that.
Judge Freeman had his hand raised before me, so he should be able to go first.
Okay, Judge Freeman.
I think I've forgotten what I was going to say at this point. I think I was just going to, this is a very well-informed group, but when we're talking about why we have higher risk levels coming in, again, I stress this routinely, but we're only administering the PSA for those who are booked. The jail booking restrictions, impact
Yes.
who is being booked and who is being administered the PSA. So if you're looking for the lower levels, those are the ones that are being PR'd or not booked at all.
So they're not getting included in the PSA. That's a good point.
Correct.
Yeah. Okay. Dave Reynolds.
Yeah, thank you. I was just going to piggyback on what Dave Graham said, and then again, Judge Freeman, it's the same thing. We're given our booking restrictions. There's really no surprise that the people we have coming in are high, that they're going to score high because we're not seeing that other population right now. So the other thing I need to point out, I spent with the judges and commissioners yesterday regarding some stuff in the PSA come up, and the commissioners are not finding the PSA valuable in their decisions to hold a release. So they've made that very clear that they do their own research regarding people's prior history and other factors, a lot of us which considered in the PSA, but they're not taking the PSA as the guidance for whether or not to hold or release someone or put them on pretrial. So I think that's an important thing we need to be made mindful of.
Yeah, that is an important thing. Judge Freeman, you have anything to add on that point?
No, I mean, I got the sense yesterday, and what I've said previously is that it's almost used as a confirmation tool. I think all of our commissioners at first appearance use other systems like JABS. So they have warrant history in front of them. They have history in front of them. And I think the extent that the PSA is likely utilized is more of a confirmation. Is it different than what they're already analyzing themselves? And if it is, then at least Commissioner Henley has told me in the past, that's how he uses it. As kind of a guide if the two don't add up, but largely what they're seeing and what Alan is saying on these high risk is that because of the population that they're seeing at first appearance, they have all of that warrant history, they have the prior history in front of them. So it's no surprise to them that they're coming up as high risk in the risk assessment. So it's just a smaller sample here than what we were dealing with 3 years ago as far as the population.
That makes sense. But on the other hand, I think it's important for us to remember that the risk assessment tool and the form that is used, that our goal was never to use that as the end all and be all. We wanted it as a vehicle to determine who would benefit most from pretrial services. And if the commissioners and the judges now have, since we instituted some reforms that get the background information circulating earlier in the day, the commissioners now have more information in front of them than they typically did back when we were pioneering the risk assessment tool. One of our goals was that tool would give the judge or commissioner in summary form the background information of the defendant. And if they can get that information easily before the hearing with the new procedures that aren't so new anymore, but that we instituted, so much the better. That it doesn't have to be through that form that they get the information, but we do need them to make the referrals to pretrial services. And I hear Alan saying that pretrial services could absorb much more. And so that's something too that we'll want to explore with the commissioners, I think. But Stephen, I think you had your hand up also.
Yes, I do. I'm sorry, I'm going to pile a bunch of reactions onto this because I was later in the queue. So there are a number of comments that I think I'd like to address. One is, way back at the beginning, one of the values of the PSA to us was that it did have flexibility, and we did acknowledge that where we drew the lines between the risk tiers was relatively arbitrary and somewhat up to us. So I don't think it's unexpected that we could alter where those lines are. And related to that, I'd like to suggest that I think it's way out of whack the way we're overweighting FTAs and underweighting pending charges. So both where that line is and how many points you get in the scoring seem to me worthy of adjustment given what we're saying.
Mhm.
So that's one set of reactions. The other is I know Dave Graham reminds us almost monthly of how serious the jail population charges are. But apparently we're booking people in with those serious charges. I've never seen any data on how many releases per month and how many new incarcerations per month happen. So I don't know what the traffic is in and out, how many people are coming in, and the fewer places we have, the more high-risk people we might not be incarcerating. That seems like relevant data to me and something we could easily get and ought to have for our discussions. So I don't know if that lands in Dave Reynolds' lap or where, but I'd be interested in that kind of information. I also think I guess I'm saying this from having been immersed for the last year in some of the needs assessment, the stakeholder advisory committee, and now the implementation planning on the needs assessment report going on. And so I've necessarily had my ear to the ground for community chatter, so to speak, more than I had in the past. And I think that there's a great deal of concern about how many people face absolutely no consequences. They're not booked, they're not monitored, that nothing happens. And there's a fair bit of community feedback that the whole community is suffering from that lack of accountability. It seems to me that Alan's suggestion that more people be referred to the PSU and at least have check-ins or something might be one way to convey some sense that they do have some responsibility toward the system, that there is somebody watching them. I'm not sure what the consequence of monitoring non-compliance would be, but I'm just trying to pay attention to responding to that community dissatisfaction. And my last comment.
Oh, I
Just
just,
one
was gonna say, I think you're really right, Stephen. Go on, please.
Okay, one last comment is the PSA or any validated risk assessment is a best practice. That's why we got here in the first place. It was intended to take away the sort of the independent subjective discretion of judicial officers in making release decisions.
Not take away, but reduce.
Reduce, yeah, check. And we even discussed at the outset asking judicial officers to explain why they would depart from the recommendation of the PSA so that we could understand the thinking of those decisions was more transparent and justifiable. So I have to say I'm somewhat disturbed at the judicial officers de-emphasis on the PSA and increased emphasis on their own subjective interpretations of what their own research takes. I sort of understand why that's happening, but I think that's going in the wrong direction. And I think that's less defensible because it either confirms your subjective view or you sort of explain it away if it doesn't confirm it. And I don't know what to do with that discrepancy, but it seems like a change of practice and not a good thing in terms of the principles that both this work group and the task force as a whole have wanted to impart to the criminal legal system. So I'll leave that pile of comments right there.
Dave Freeman, do you have any response?
Well, I think I was not here when this was initially implemented, but my understanding from the beginning was that it was not meant to take away the discretion of the judicial officers.
Right.
I do agree with Stephen that, I would like to see it used and considered by the judicial officers, no question. But I don't think the intent of this recommendation has ever been to take that discretion away.
No,
and that concerned me a little bit, the idea of that, given our system.
Let me just respond to that briefly, Dave. I think Stephen, overemphasized that aspect of things in light of his concerns. But always we have said that the discretion of judicial officers is always there. It's always a piece of things, and it should be a piece of things. Otherwise we could have a computer making all these decisions, and that's not anybody's intent. But it was our intent to use a risk assessment tool to bring to help promote consistency between decisions. And we know that inconsistency and subjectivity often lead to results that are racially and ethnically disparate. They're not consistent. And one thing that we looked at every time in all our discussions in selecting a risk assessment tool was to select one that would certainly not promote that kind of disparity and would instead look to reduce it. And the one that we chose certainly has done that in other jurisdictions, and on our fledgling numbers seems to be helping us as well. So I don't think the goal has ever been to take discretion away from judicial officers, but rather to help them. And
Yeah, thank you, Judge Garrett.
Yeah.
That's much more artfully stated, and I'm sorry I misconveyed what my meaning was, Judge Freeman. I wasn't trying to take away discretion. That's always been built in, but I think that discretion to depart from, I think the framework in the majority of cases, maybe what the ideal was to use that more objective, more structured kind of assessment, and then have the discretion for some number of but I'm probably a minority of departures from that. I think what I heard, and maybe that's not accurate, is it's flipped, where the discretion is the predominant determinant over the risk assessment tool.
Well, and part of my concern is that first of all, I have always fully supported the risk assessment tool, in part because it gives us a measurable, baseline. I think part of my concern is what Alan had indicated earlier, and that is when the commissioners are seeing virtually everyone coming through under a high risk level, then of course what they're seeing through history and through warrant history, through pending charges, of course that's going to line up with the risk assessment tool, because that's what they're only seeing, those high risk folks come through.
mhm.
So I think that's, I don't want to overemphasize the risk assessment tool if that's all they're seeing is high level. Because it is somewhat confirming of, and I agree with you, Stephen, that that's just kind of a confirmation issue at that point. The only other thing that I wanted to address in Stephen's comments were, I appreciate that sentiment as far as, do we want to look at other aspects as far as, monitoring and more accountability. I think there's some fear amongst the bench in that we do things that we can't enforce. And I do have some concern that, sure, we can put everybody on pretrial monitoring, or we can put them on an EHM, but can we enforce it if there's non-compliance? And the last thing that I want to do as a judicial officer is to essentially order something that I can't enforce. And so there is some hesitation here based on the current jail restrictions and what we're facing as to whether we could actually back up our court orders. Despite, I understand the sentiment.
Yeah, that's the bind we're in right now.
Hold on, I'm just making a note here. So, I
Let's
do
hear-
think,
Sorry, Dr. Peterson and Dave Reynolds have their hands raised.
how is it that you see hands raised? Is it the physical hands and I'm just not looking, or is there some sort of signal on the computer?
There is an icon in the top left corner. If you're looking at your
Oh.
gallery view, if you have gallery view set, so you see everyone, there's an
Okay.
icon in the top left
Okay.
corner.
I'm sorry, Jill, maybe
Okay.
you and I can stay on the phone when the meeting's done and you can give
Sure.
me a tutorial, but let me just apologize to everybody I've ignored. I don't have that in my computer and that's why I didn't see you. So I think that it's Dr. Peterson and Dave Reynolds that both want to make comments. Is that right? Okay, go for it.
Dr. Peterson, go first.
Dave, why don't you, did you, okay,
Thank you,
Andrew?
David. Thank you, Judge Garrett. Yeah.
okay.
A couple points. One, and I'm always wary because I know judges only sometimes listen to researchers in the first place, so I don't want to tell anybody their business. But as I recall, the guidance from the APPR is not that the PSA weighs in on release decisions, but that it weighs in on supervision. So the judges are supposed to be following Rule 3.2, right, in release decisions. So that's so I think that's important that that's clear, and that's what's happening. Stephen talked about kind of reweighting the PSA elements. Just a reminder that they're weighted as they are for a reason right now, because that they're correlated with people coming back into the system, and so we want to be careful before we kind of just do that. It's very possible that these current weights were created in a pre-COVID climate. And now that we're in this, new conditions and new things happening, they are less correlated than they used to be because the situation has changed, and that should be considered. Related to that, I was just in a meeting earlier this week with Pierce County. It's also, doing this, implementing the PSA and reforming their pretrial system. And they presented this exact topic. So risk scores prior to kind of the COVID period, right, where they validated the PSA based on I think it was like the 2017 and 2018 jail bookings, and compared that to all jail bookings since this program started, which is essentially the COVID period. And there were a lot, the folks were a lot riskier, for lack of a better term. So you saw a lot more of the category 6s, category 5s, and fewer of the category 1s and 2s. And so they kind of came to the same conclusion that, those folks are just not even getting booked as often. There could be other factors too, but that was kind of what they thought was most relevant. And then third, and thinking about this in a way to kind of get around this and give us more insight, because the AOC gets records of all cases or all charges filed. What we could do is just look at those same factors. If we have the case being filed, we know the person, we can look back and look at their criminal history. So we can actually kind of create a hypothetical PSA, even though one was never formally administered, and see, how did the PSA scores or hypothetical PSA scores of all individuals who have cases filed, what do they look like versus just those that, were booked into jail that had a PSA administered. So that might give us some more insight to that topic. Sorry, that's a lot I noted there, but.
Is that a pretty time-consuming thing to do? It sounds like it would be.
I mean, it's not a zero time thing, but if I can kind of do the computer code to create the score, it's just starting with one group, versus starting with another group, and then just applying that same program to them. So, I mean, it's not, like I said, it's not zero, but it's not going to take days or weeks kind of thing. Or it won't take weeks, it might take days.
Hey, Andrew, I hate jumping ahead of people to hands, but while we're talking about it, can you start with people who've been booked and released from the jail? I know you get like bookings from the jail, or would it just, because that's one we're kind of curious, because those are people that the officers at least have physically transported to the jail and have been told are just, been told this is, we're too full, or, we're not booking on this sort of offense, versus the regular summons cases that, I get coming in. Is there a way to distinguish that at all?
And sorry, Dave Reynolds, for keeping you waiting on this, but maybe I can look into it. I don't regularly get jail data. I got it that one for the last meeting, and it wasn't the best quality in terms of linking it to the AOC records. They don't record case numbers faithfully for all the records. So connecting those two things it's a little bit of a fuzzy, process. So I can try, and again, it'll also, well, I can try, and we can, maybe we can talk a little bit about what those folks would look like in the data in order to make sure I'm getting the right people. So we can continue talking.
Okay, yeah, because now you mentioned it, they won't have a case number assigned till sometimes a week or two later, so that would be tougher.
Yeah, but I'd really like it if again, Dave Reynolds will get you into this discussion too, but it would be Andrew and Dave Graham, it would be really nice if you could work together to get each other the information that's necessary for Andrew to analyze that. Dave Reynolds, what's your view?
Thank you. I just want to clarify my earlier statement about the risk assessment. I think I'm going to piggyback a little bit on what Dave Freeman said. Judge Freeman said, I think the commissioners are using it to confirm kind of what they're able to see. They're given enough information now, because the type of offenders we have coming through, the history, failure to appear history and criminal history and stuff like that's weighting so much, which it may not have on the different population, that they're seeing that information already, really make judgment calls on that. I do think we have an opportunity with the amount of PSAs we've had administered right now to take a look at why are those people failing? You know, what are the factors? Is it the risk? Is it the warrant history? Is it the criminal history out there right now? And I think before we make any changes or look at putting additional people on pretrial, we need to be looking at what those things are so we can start to address those first. I think simply putting them on pretrial and we're already having people not show up is not going to improve. What's the reason people aren't showing up on there? And hey, I don't know if Alan can answer how many people we have under low risk, moderate, and high at the moment. What the breakdown is on that.
Alan?
I'm out of the office right now, so that's why you can't see my video.
Just roughly.
I know we have more on medium.
Alan, hang on. Alan, you have two audio sources open, which is creating feedback.
Dave Reynolds, can you mute a second?
There we go.
Was that it?
Yeah, it's okay now.
Okay. I don't know exact numbers without staring at CE, but I will say mediums. I have most on medium. I have the second on low and then highs. And the numbers we're talking about, again, we have 67 cases total. So if we break that down kind of by category, I would say maybe 40 of those cases. And again, I'm talking cases, not people, because so if one person has three cases, that counts as 3 cases. So when I'm talking 67 or 66, I think I'm at now, it's 66 cases, but we're probably closer to about 50 something people. I would say a majority of them are medium.
And their phone, the medium's just phone check-in?
A medium is they check in office at first, and then they'll switch to phone. And if so, and I'm also, I've been kind of given the discretion that if they're checking in regularly and they're doing very well and they're keeping up to date, either talking to their attorney or communicating with my office well, that we go like once a month instead of once every 3 weeks or once every 2 weeks.
That makes sense.
So I'm wondering if we could get information about what the risk levels are for those people who aren't being successful on pretrial and look at adjusting based on that. You know, is it moderate people who aren't, and maybe we need to be seeing them more often? Or is it the high risk who aren't, or is it the low risk who are getting pulled in to non-compliance because they're being monitored when they wouldn't otherwise? Dr. Peterson, do we have enough information to gather any of that?
I think we should, depending on the time frame you want to look at, how far back you want to go.
And if I could just, I'm sorry, go ahead.
No, you go ahead, Alan. You go ahead and I'll be next. Go ahead.
Okay, I wanted to piggyback on what Dr. Peterson said about 5 minutes ago, is that I made it sound like we can adjust how things are scored on the PSA, and Dr. Peterson was absolutely right. So the PSA was designed by Arnold Ventures. I can't change how things are weighted.
Right.
All we can do is adjust where the matrix, like what that little box says, if we wanted to say medium, low, or high.
Where we draw the line, because we're the ones that draw the lines between
Correct.
medium level and high level and low level. Yeah. Which I think we should be better equipped to do when we get the insights from the statistical information that Andrew is going to put together. And I'm wondering, what can I assign a homework assignment to Dave Graham and Dave Reynolds and Alan and Andrew to work together on amassing the case information that will give Andrew the tools he needs to analyze the reasons for people's failure on pretrial services, and whether the high scores people are getting have to do with new crimes or failures to appear in the past, or those topics that we discussed before. Can is there 4 of you? Can the 4 of you take that on?
Sure.
Dave Graham, you look doubtful, but
No,
Will,
I'm just trying to think what input I could have. I was thinking what I should probably do is to figure out some sort of way, since I do the arraignments every Friday, if I could send Andrew a list of the people who've been booked and released with their new case numbers. So then he'd be able to do sort of a hypothetical service on that. The other aspect, I mean, I can help out. They need something from me, of course, but that's why I was just doing my thoughts. I don't know on the failure or non-failure or the different levels of, because I don't really see those, but yeah, I'll help whatever's needed.
okay. And Dave Freeman, I hear Alan say that it's possible for the pretrial services unit to take in more people and monitor them for, pretrial. Can you talk to the commissioners about referring more people to pretrial services?
Yeah, I can definitely have that conversation. And I think we have had the conversation as well as to whether potentially those people being booked and released and being seen for the first time on Friday, whether that should be a population, even if they haven't had the risk assessment,
I agree.
whether they should be considered for pretrial services as well.
Yeah, I really agree, and I know Alan does too. I don't know that we want to send all those people to pretrial services, because there may be some that are just,
Sorry, it's so hard the double echoing.
oh, you're hearing double echoing. But I'm not in the courthouse.
No, it's okay. Sorry, the last
stop.
bit of what you said wasn't working.
Okay, I'll stop. And I see Stephen. 3 people have hands up, and Stephen, why don't we start with you?
I just wanted to be clear that I wasn't necessarily advocating for changes to the PSA, and I take Andrew's point very well about it determining the level of supervision rather than the yes/no decision on release. All I was trying to say was we have more flexibility on this than we were talking about, and I think we've been, for months in these discussions, we've been flying blind, and the kind of data gathering and analysis that we've been talking about the last 15 minutes is exactly what I think we need. And so
Okay.
I look forward to getting that information, because we don't know what we're talking about otherwise. I mean, or some of us do and others don't, and we're talking across each other.
Fair enough. Adam, did you want to make a comment?
Yeah, I just had a question for Alan. I used to attend our OWG meetings where we review referrals for potential lead clients, but due to my adjusted schedule, I haven't been there lately for the beginning of this year. But in the past, I had not noticed if we had gotten any, or I don't think we received any referrals from pretrial services. And please correct me if I'm wrong, I just hadn't noticed that. So my question for Alan was, if you see red flags that somebody is probably not going to be successful with the pretrial services and checking in, are you able to send a referral? Do you have like a process of when you flag somebody like that, if you feel like they might need intensive case management, to refer them to a service like the LEAD program?
I haven't necessarily in the past, other than I will say, if somebody comes in and based on their snapshot of their criminal history, and it looks like they have FTAs, and it looks like they might have some housing issues and things like that, I will have them reach out to you. Now, previously, I haven't had a formal template or form or anything like that I've sent to anybody in LEAD, but I have mentioned and directed them to get a hold of LEAD to see if your services can help them at all.
Sure. Well then, so I won't go into detail of the process, but yeah, it wouldn't work out probably that an individual would just reach out to LEAD. We usually have to have like a referral from an agency or some community partner. So if it's okay with you, if we can follow up afterwards, maybe that's something that we could address, so have people be more successful with connecting with us.
Absolutely.
That's good. Why don't you two follow up on that, and then we'll look forward to hearing from you about progress on that at the next meeting. Dave Reynolds?
Yeah, thank you. I think it's important to point out if we're looking at gearing things up, Alan's the only person in pretrial services right now. So he's going to be responsible for everything that goes on. He's going to have vacation time coming up. He's going to have some other stuff. So I think we need to be mindful of that piece. We're a one-man show at the moment. And we don't want to build too far where we can't handle that. I think we need to be smart about how we move ahead.
Yes, good point. Alan, mission creep, it can always be a danger. Yeah.
Thank you, Dave. Yeah, I mean, I would obviously try to put my best foot forward and do my absolute best, but limited personnel might limit me.
And Maya?
Thanks. I think when you were, sorry, getting echoey, I was understanding that there was a suggestion that folks who showed up on the Friday calendar for their first appearance or first appearance in arraignment, that maybe at that time, pretrial services would be required. Was that what I was hearing?
I don't think so, but Dave,
Okay.
Dave Graham, you want to answer that?
I thought maybe Judge Freeman mentioned that.
Yeah, I did suggest.
Oh,
that.
I'm sorry. Okay.
Okay, so oh, go ahead.
That there had been a suggestion that from Alan that more people be referred to the pretrial services, and on a case by case, I think the commissioners should be considering that at first appearance on Fridays.
The book and release people is what he's talking
Yeah.
about.
So
Mine,
I
not
guess
the summons.
our position would be like they appear, they're showing up, and that's really what bail and release conditions are for. And if they're appearing and haven't gotten any new criminal charges, that it seems that's not very least restrictive, which the rule requires. So I would question that as a path we would want to go down. So
I will say that before those calendars, I have fielded phone calls before, like on Wednesdays or Thursdays, that the person received a text message and says, hey, I got a text saying me or somebody I know, or that sounds like me, has court this Friday. Can you tell me about that? And oftentimes it is the people who are summoned or who had no idea they had a court case pending. So in a way, pretrial is already helping them.
And Maya, I think your question is well taken and an issue that we should discuss, but I don't want to talk about it in depth until we have better numbers. And that's what we hope to be getting from the numbers committee that we just appointed next, at least preliminarily at our next meeting. So we're not going to put your question aside for good, but for right now, yeah. Well, I think we've had a good discussion today. Is everybody clear on their homework assignments? Not everybody has them, but the numbers guys certainly do. And Adam, we haven't given you any assignments, but I'm hoping that well, actually we have, because you'll be working with Alan on that referral process. And Alan, to the extent that that you can be helpful with the numbers, you and Dave Reynolds can work together on that. And I'm sure that that you'll get all the help you need from anybody else who's involved. So, do we have further discussion now, or should we defer the remainder of this discussion to our next meeting? Jill, can you remind us when our next meeting is?
Yes, thank you. Our next meeting, the first Friday, is Friday, May 5th.
Okay. And numbers guys, led by Dr. Peterson, do you think you can get the information you need to Dr. Peterson in time for him to give some at least preliminary insights to us at that May meeting?
I mean,
Dave,
I'll give him whatever he needs on CE. I'll do my best.
Okay. Okay, so maybe Dave Reynolds and Alan and Dave Graham, if it would be helpful, and I think it would be, can meet telephonically with Dr. Peterson, and the four of you can figure out exactly what information he needs and how he's going to get it. Can we leave that assignment to you to be done within the next week or two so that Andrew can get going with those numbers? Is that,
If you just tell me what he needs, I'll get him what I can.
okay?
Yeah, I have no worries that Alan and Dave can help out. I just worry if we need jail data, that might be a tight timeline.
Well, that's part of the reason I'm asking Dave Graham to join you, so that he can be a conduit if necessary.
Yeah, I think what I can probably do is we won't have to go through the jails. I can just mark all the people and give you like the case number who got booked and released. Because they have blue sheets on our Friday calendar. And so maybe I'll just end up scanning that list to you. I can just highlight them or something like that. But we can talk about that. But
Yeah.
I'll try to help with it, those PRs.
Good.
Thank you.
Okay, Maya, you can get the last word if you want. Oh,
Well,
there's-
I'm not here that May Day, but if there is a discussion that is it possible to get minutes from these meetings, or is that not possible? Or, I mean, I don't need them if we're just like, oh, we don't have the data yet, let's figure out how to get it. But if there's some meaningful discussion, I'd like to hear or be able to review it.
Meetings are posted on YouTube shortly afterward.
All right,
Okay,
thanks.
and Judge Freeman, you get the last word.
Somewhat unrelated, but I just wanted to check with Stephen whether whether this work group had a specific assignment coming out of the Justice Project as well that we need to put on for our next agenda, or
I'm not aware of one at this point in the process, but I will check back on that and let you know if I'm wrong.
thank you.
And Judge Garrett, we have one quick agenda item on the annual report that I think Jill Nixon is best situated to bring up.
And Jill talked to us a little bit at the very beginning of the meeting. Jill,
I'm sorry, I missed
when is that report going to be due?
The final report is due to County Council on June 30th. But we hope to have first drafts done by folks at the end of April or early May. And that's first draft only.
Okay. Maybe we should start off with me and Stephen Gockley working together and then expanding the draft if necessary. I'm thinking we're just one committee that's one of many reporting, so probably we just need a paragraph or two, right?
That's correct. And also because of all the work everyone's putting in on the Justice Project, we're keeping this year's annual report pretty small and contained. So it does not need to go into a great amount of detail.
Okay. Stephen, I'll call you right now if you want. When we get out of this meeting, I'll call you on the phone and we can talk about doing a draft paragraph or two for that report.
Yes, I'll make myself available. I just wanted you to know that Monday I am leaving town. I'll be gone for 2 weeks. So I think a lot of the drafting might fall in your lap, Judge Garrett, and I'm sorry for that.
Oh, that's okay. I hope you're going someplace fun, but we'll talk.
I am.
Yeah. Oh, good, good. All right. So I think that does it for today's meeting.
Excuse me, Judge Garrett, we do have one attendee and we'd like to offer them opportunity for public comment.
Okay, please explain to the attendee that the person chairing the committee, me, has limited computer skills and therefore didn't see that someone was here and wanting to make a comment. I didn't mean to ignore them. Go ahead, please.
Yes, thank you. If you'd like to speak to the work group, please virtually raise your hand now by selecting the raise hand icon. Okay, Kristen, go ahead and unmute yourself.
Oh, I wasn't even going to make a comment except to let you know that it was me. And it was a really good meeting. I enjoyed all of the information that was shared, and you know, I'm looking forward to reading the nice, crisp report that the few paragraphs that you'll be writing here.
That we'll try. We'll try. Neither Stephen nor I is noted for being especially taciturn, but we're going to do our best.
All right. Well, thanks for all this work that you're doing on this project. All right. Thanks.
Thank you for your interest, and thanks to everybody for attending today's meeting. We'll look forward to seeing you on May 5th then.
All right, thank
Okay.
you.